I'm going to discuss three separate topics in this video. The first topic will be my reaction to part of the interview given by Chris Sununu, the Republican governor of New Hampshire, in his interview yesterday with George Stephanopoulos. The second will be, in my opinion, on Judge Merchan's decision on admitting the Access Hollywood tape or transcript in the current New York criminal trial that is ongoing now. And the third topic will be the current status of the E. Jean Carroll appeal that is now pending before the United States Appeals Court for the Second Circuit. This is a federal appeals court. The case was tried before Judge Kaplan, a federal district court judge. The Republican governor of New Hampshire, Chris Sununu, stated in an interview yesterday that he will vote for Trump, even if Trump is convicted of a felony before the election. Sununu made it clear that he will vote for Trump, notwithstanding his opinion that Trump contributed to the insurrection and lied about the election being stolen from him. Both of those beliefs go to the very foundation of what it means to be living in a democracy. Both claims are heresy in Trump's party, and the party, the Republican Party, is now Trump's party. All of those considerations, like one or more possible felony convictions before the election or after, do make Sununu a little bit queasy and uncomfortable about voting for Trump, but he will get over that and vote for him nonetheless. Sununu is viewed as a moderate Republican, which doesn't mean the same to me as what a moderate Republican used to mean back in the day when they were mostly living in the Northeast and New England. A moderate Republican in Trump's party is someone who is not a full-fledged member of Trump's personality cult, but who will vote for him notwithstanding reservations about his character and even criminal convictions. In short, they reach the same endpoint as a cult member and need to be lumped into the same pile for future reference, in my opinion. Sununu claimed that 51% of Americans supported his stance on voting for Trump. Maybe that is overstated some. Now on to the second topic. Judge Merchan ruled that the prosecutors cannot play the Access Hollywood tape, which probably everyone in the United States has viewed at least once, but may introduce a transcript of it during the trial. The transcript is relevant evidence in that it explains the urgency of the Stormy Daniels hush money payment made shortly after the Access Hollywood tape was released to the public in early October 2016, and the importance of that payment in furtherance of the campaign, making it a campaign contribution that was not disclosed as required by law. The judge, in making that distinction between the tape and the transcript, is attempting to balance the evidentiary value of what was said, which can be read in the transcript, with the possibility of inflaming any juror who has not seen or heard Trump's comments, which may be no one. So it is a sort of a compromised evidentiary ruling that does not change anything, in my opinion, and takes away a ground for Trump's appeal. He is claiming error in admitting the tape in the first E. Jean Carroll defamation case, but the tape was probably more relevant in that case since the statements made by Trump about sexually assaulting women was directly supportive of E. Jean Carroll's sexual assault claim. Now the third topic. I took a look at the United States Court of Appeals for the Second Circuit docket sheet for the Trump's appeal of the first E. Jean Carroll verdict, and this one is important also for the second trial verdict. A joint appendix was filed on November 13, 2023. Both sides have filed their supplemental appendixes, which apparently included material that they couldn't agree on mutually. The recent entries also show that both Trump and Carroll have filed briefs. Trump's obtained an extension for filing a reply brief to Carroll's brief, which has to be filed now no later than May 1st, 2024. I would anticipate an oral argument within a few months after that and a decision before the election. These filings can be viewed at the Court Listener, that's all one word, website under Carroll v. Trump, docket number 23793. The jury found in that case that a statement made by Trump in 2022 when he was a private citizen was defamatory. Trump's statement basically called Carroll a liar when she asserted that Trump had raped her. The jury finding in that case that Trump was liable for defamation resulted in the second Carroll jury trial being solely on the issue of damages, since parties are precluded from relitigating an issue that has already been decided in a verdict on that issue. That is called collateral estoppel, which is probably more than you want to know about legal doctrines. It is a doctrine that has been around for several hundred years and was not concocted to prevent Trump from relitigating his liability for defamation in the second trial. I mention this now to emphasize that if the Second Circuit reverses the first Carroll verdict for any reason, then the second trial verdict on defamation would necessarily fall as well. So what collateral estoppel giveth, it can taketh away, requiring the entire defamation liability issue to be relitigated in both cases when and if the Second Circuit reverses the jury verdict. I do not expect that to happen.